Imagine a cornerstone of American democracy, built to combat the deep scars of racial discrimination, now teetering on the edge of being dismantled by the highest court in the land. That's the heart-wrenching reality at stake as the conservative-leaning Supreme Court gears up to tackle a pivotal case from Louisiana, potentially stripping away a crucial safeguard from the iconic Voting Rights Act of 1965. But here's where it gets controversial. Could this decision pave the way for a colorblind approach to elections that some say protects equality, while others fear it erodes hard-won protections for minority voices? On Wednesday, the justices will dive into oral arguments about whether states should be allowed to factor in race when redrawing congressional districts to align with Section 2 of the Voting Rights Act. This powerful section, enacted amid the civil rights movement's fight against systemic racism, empowers courts and officials to ensure that minority groups, particularly black voters who faced brutal disenfranchisement, have a fair shot at electing representatives who reflect their communities. For beginners diving into this topic, think of it like this. Just as a school might adjust its rules to help students from disadvantaged backgrounds catch up, Section 2 lets states tweak district boundaries to counter historical voting barriers, preventing tactics like gerrymandering that dilute minority influence. The case stems from a protracted battle over Louisiana's congressional map. Last year, after facing a lawsuit under the act, the state redrew its districts to create 2 majority black areas, up from just 1 in the original map. Louisiana's population is about 1/3 black, so this adjustment aimed to address the imbalance and give these voters more equitable representation. It's a real-world example of how redistricting can either bridge divides or widen them. Imagine if your neighborhood's boundaries were shifted in a way that made your vote count less, simply because of your background. Initially, the Supreme Court examined this dispute through a narrower lens earlier this year, focusing on specific legal details, but in a surprising June twist, they expanded the scope dramatically, inviting the parties to revisit broader constitutional questions. Now, the big question looms. Does crafting maps to prioritize majority black districts clash with the 14th and 15th Amendments, those post-Civil War additions to the Constitution designed to guarantee equal rights and voting access for formerly enslaved people? These amendments, ratified in the aftermath of the war, were meant to shatter the chains of discrimination and secure freedom for all Americans, including through the ballot box. Conservatives on the court and beyond champion a strict, colorblind reading of these amendments, arguing that any consideration of race, even in the name of fairness, violates the spirit of equality. They've pointed to a landmark 2023 decision where the court struck down race-based affirmative action in college admissions, emphasizing that the Constitution demands we look beyond skin color. For instance, this view holds that treating people differently based on race, even to rectify past wrongs, undermines the ideal of judging individuals solely on merit. It's a perspective that resonates with those who see such policies as outdated or even reverse discrimination. Louisiana, which had first stood by its revised map, has since flipped sides, aligning with a coalition of non-African American voters challenging the changes as unconstitutional. The Trump administration has also thrown its support behind this stance. On the opposing side, civil rights organizations that originally sued to force the redistricting are defending the map, highlighting how it honors the act's intent to protect vulnerable groups. The Voting Rights Act itself has been under relentless conservative scrutiny, with the court chipping away at its protections in major rulings back in 2013 and 2021. Yet just 2 years ago, in a twist that surprised many, the justices affirmed the need for race-conscious redistricting in a separate Alabama case, ruling 5-4 to uphold district adjustments that boosted minority representation. Notably, 2 conservative justices, Chief Justice John Roberts and Justice Brett Kavanaugh, joined the liberals in that majority, though Kavanaugh hinted at doubts about Section 2's future viability. And this is the part most people miss. That delicate balance shows how even colorblind advocates can sometimes bend toward pragmatic fairness when the stakes involve real electoral access. If the court rules broadly in Louisiana's favor, it could fundamentally alter how states approach redistricting, potentially slashing the number of districts where minorities form majorities, and consequently, reducing the ranks of minority lawmakers in Congress and state houses. With black voters leaning heavily Democratic, such changes might tip the scales toward Republicans in elections, a political ripple effect that's hard to ignore. The timing adds urgency. A swift decision could allow Louisiana and similar states to revise their maps before the 2026 midterm elections, potentially reshaping political landscapes for years. Proponents of the colorblind view argue it's about leveling the playing field for everyone, but critics warn it's a step back toward the disenfranchisement the act was born to fight. Is this a noble pursuit of true equality? Or a dangerous rollback that ignores America's ongoing struggles with racial justice? What do you think? Does considering race in redistricting fix old wrongs, or does it perpetuate division? Share your thoughts in the comments. Let's debate this pivotal moment in our democracy.